Thank you, Deputy Speaker, and thank you for giving me the call. I know it's sometimes difficult for you to so do, so I appreciate it.
It was a pleasure.
I rise to speak on the Courts Administration Legislation Amendment Bill 2015. This bill, on one level, is quite simple in that it merges the corporate functions of the Federal Court, the Family Court and the Federal Circuit Court, and I say up front that the Labor Party is broadly supportive of this piece of legislation. In terms of a little bit of background, the Family Court and the Federal Circuit Court have jurisdiction to hear family law cases. As the Shadow Attorney General to the as the Shadow Parliamentary Secretary to the Shadow Attorney General, I have a particular focus on family law. It was my area of law before coming into Parliament, but since receiving this responsibility from the Leader of the Opposition and the Shadow Attorney General, I've consulted right across Australia with family lawyers. I've employed a family law barrister, and I've had a lot of consultation with family law, from Cairns to Townsville to Brisbane to Toowoomba to Sydney to Melbourne to Adelaide and even Perth, Deputy Speaker. The consultations with family lawyers and legal aid who deal with the consequences of breakdown in relationships is certainly heartening and disturbing, because it's always difficult when love turns to hate. Obviously, I think 91% of the filings in the Federal Circuit Court last year were for family law proceedings. I should point out front that some people, many people I guess, when relationships end or disintegrate, they sort out their own lives outside of the court process, or sometimes they just need a sort of a signing off on arrangements that they've come to. Unfortunately, there will always be some relationships that require legal intervention. So the 70% of people who actually have contact with the family law legal process do not go to a trial, but unfortunately some do. These courts, the Federal Circuit Court and the Family Court, hear complex family law cases involving often involving family violence, involving abuse, involving mental health issues, involving drug addiction. So I'd like on this day to particularly acknowledge the judges and the staff that deal with the people presenting this information. It's often difficult information. Unfortunately, people can misrepresent facts, and sometimes there are often in these proceedings people are unrepresented, and that creates additional stress where judges are trying to be supportive, but obviously also you need to be able to test evidence. You need to be able to test what people are saying. Unbelievably, it's hard to accept, but sometimes people lie in these circumstances. They lie because when love has turned to hate, people can be motivated by it, well, they don't always act logically. Sadly, there's been lately some strong and consistent criticism about the state of the family courts in Australia. That criticism has been sustained for quite a while. From Launceston to Cairns, family lawyers are speaking up, writing to the Shadow Attorney General and to me. They're writing to the Attorney General because of the same concern, which is that delays are increasing. And I note the member for Parramatta and the member for Isaacs touched on this in their earlier presentations. People are waiting, in some cases, up to 3 years before they can get in front of a judge. 3 years. Now, there is no doubt that families are suffering because of these delays. And when I say families, it can be the children especially, because the family law has a particular focus on children, but also the mum and the dad. All can suffer because of the uncertainty, all can suffer because of the delay. A child living with parental conflict already has a tough cross to carry, but if they have to wait another year, it would seem a lifetime for that child. And if the conflict is continuing, and in some cases escalating, because of the delay, over a period of years, that can literally be the child's whole life. Their childhood is locked into a set of circumstances where there is no certainty, where the uncertainty creates extra damage. And as I said, not just to children, but to mums, but to mothers and to fathers. So these delays have been made intolerably worse by the Attorney General's tardiness when it comes to replacing judges in the family courts. Now, the Coalition have been in office for 910 days. It does seem a lot longer, but 910 days, yet it took Senator Brandis, the Attorney General, 560 days to replace a judge of the family court in Sydney. It's taken him 375 days to replace Justice Bell in the Brisbane Registry, with the replacement judge still not yet sworn in, although I do wish her well. Across the country, there have been Federal Circuit Court judges retiring and long delays in their replacements being appointed. And I should just point out, Deputy Speaker, that this is not due to dollar issues. These positions are funded. These positions are budgeted for, and there is no saving for the government by not replacing the judges when they're going to retire. And remember, in the family court, we knew that Justice Bell was going to retire from about 40 years ago. There's a set time, so it's not as if it was suddenly sprung on him that Justice Bell was going to retire. Delays in replacing retiring judges has caused huge backlogs of work that these registries will never recover from. And if a judge gets sick, it's not as if their docket is taken care of. These delays are compounding, creating backlogs of misery, bottlenecks of heartache, where families suffer because of the Attorney General's tardiness. The former Federal Circuit Court judge, Giles Coates, delayed his retirement for 6 months so that there would be no delay, yet still there was no replacement ready when he left mid-last year. Judge Coates reportedly accused the government of neglect for failing to appoint family law judges in a timely manner, and that's a quote, and that the delay in appointing judges had caused court lists to blow out and children had been put at risk. I repeat that, children had been put at risk. And Judge Coates went on to say, and I quote, "These cases involve dysfunctional parents because of drug abuse, alcohol abuse, domestic violence in all its forms and mental illness. That represents a real danger to the children. Until a case can be heard and finalised by a judge, those risks are continuing." End quote. The Attorney General finally appointed replacements for 2 judges in the Family Court and 2 judges in the Federal Circuit Court last week. Only now will this take the courts to a full complement of judges in those courts. However, the damage caused by the delay has already been done because the Attorney General, it's not as if he was busy with his arts portfolio. That was stripped from him by Prime Minister Turnbull because of incompetence in that portfolio. He had time to focus on being Attorney General. These delays are unforgivable. These are courts that are already under enormous pressure due to the nature of the cases that come before them, as I said, Deputy Speaker, because people are often motivated by perhaps less than pure reasons when it comes to children and former partners. They can make all sorts of accusations, and it can be very difficult for judges to extract what is in the best interests of the child, what is truthful, how will society be better for their decision. A lot of faith is put in the reports prepared by the the people that prepare the reports, and it is not exactly a lucrative area of work, yet they are relied on, these reports about children, relied on as if they've been written in stone and brought down from Mount Sinai. And so if the family court report writer does not get it right, there can be incredible consequences for children. The Children's Commissioner, Megan Mitchell, was just this week reported as questioning whether the family courts can properly deal with the damage family violence does to children who are the subject of contested parenting applications. So, I would ask the Attorney General, when it comes to dealing with the family courts, the Federal Circuit Court, to do some broader consultation, to talk to the lawyers that work in this area. That is obviously very important. Family law lawyers are a very special breed of lawyer, I would suggest. It's a particular calling. So consultation with them is important, but also the women's legal services, the people that provide advice about domestic violence, the men's groups who are involved in this process as well. I'm not sure that consultation occurred with the Attorney-General's latest effort, which is the binding financial agreements. I'm not sure if there was a lot of consultation with the women's legal services throughout Australia. That's not what I'm hearing at all. So I'm hoping the Attorney-General can do his job and focus on family law, because so much damage has been done by the delays. Now, as I said, I recognise that he appointed 6 more judges recently, and I particularly will praise the Attorney-General for the fact that some of them had family law experience. But obviously I could then spend another couple of hours talking about the consequences of the legal aid cuts and the uncertainty out there in the community legal centres, where people are waiting for these cuts of up to 30% to be rolled out. People that want to, feed their children and pay their mortgage, all those things that lawyers need to do, and some of them will take their experience and leave the community legal centres and find work elsewhere, and that would be a great shame, because it's not exactly well remunerated legal work, but it keeps society humming along. That's just not me, a bleeding heart lefty, saying that. The Productivity Commission actually said that we need to pump more money. We need to pump more money into the legal aid system. Yeah, so the Productivity Commission, not exactly a bastion of left-wing ideals, they're saying that there should be more money pumped into it. So this bill before the chamber will merge the corporate functions of the Federal Court, the Family Court and the Federal Circuit Court in order to make savings through efficiencies, a measure that was announced in the 2015 budget. So the 3 courts will share their corporate services. The CEO of the Federal Court will have responsibility for managing these shared resources. There has been consultation with the Shadow Attorney-General, and I would commend those that are doing the merging with the consultation with unions and with those that will have to work under the new regime. Obviously, all change is stressful. All change is stressful, but the people merging these corporate services have done a good job. I would commend them for that. I'm sure that those reporting to the Attorney-General will report that back, that I do have something nice to say about some parts of the process. This measure was first announced in the 2015 budget, as I said. So Labor supports efforts to streamline corporate functions of the 3 federal courts, although there is some concern from the Family Court as to how this measure will be implemented in a practical sense, but I'm sure that will be, I'm hopeful that will be sorted out. It will achieve some modest savings, and they will not go anywhere near resolving the problems facing the courts at the moment, but Labor supports this measure as it is a start. They say that a journey of 1,000 miles starts with a single step, so I'm hoping the Attorney-General doesn't rest too long after taking that first step, and wish him well with this piece of legislation.